Today I, Vasudha Pandey, with my co-host Pradyuman Pratap Singh, welcome you all to the third podcast of our channel. Today we are here in the benign presence of Miss Mariyam Khan. She is currently pursuing her PhD in criminal law. Thank you so much, ma'am, for coming today.
Thank you, Vasudha. Thank you, Pradyuman. Thank you for having me over.
So our first question is, according to your experience, what is pre-trial detention, and what is the difference between pre-trial detention and judicial custody?
See, if we look at the criminal justice system in India, basically the trial of a criminal offense is spanned over three stages. You have the pre-trial stage, then you have the trial stage, and then finally you have the post-trial stage, wherein an accused may be convicted or acquitted eventually depending upon the outcome of the case. If we talk about pre-trial detention, it is the detention of the accused in the custody of the police where even the trial has not started. The framing of charges has not taken place and the accused is apprehended merely on the basis of probably an FIR or a complaint that may have been received by the police, or even at times if the offense is grave in nature, even on a suspicion by the police, the accused may be taken into custody. However, this pre-trial detention is of a temporal nature. Accused cannot be kept in the police custody for a period extending beyond 14 days. And more importantly, when an accused is apprehended by the police, he has to be presented before the magistrate within the first 24 hours itself. However, when it comes to judicial custody, see, if I put it in simpler terms, judicial custody would mean the apprehension of an accused in the custody of a magistrate or court. When the apprehension or detention of the accused is facilitated and ordered by a magistrate or by a court of law, it is referred to as the judicial custody. A judicial custody is a much more safe environment for the accused to be in, because see, usually whenever the accused is in police custody, there is always a presumption running that he may be subjected to some kind of violence or torture in order to extract information out of him. If we look at our Bharatiya Sakshi Adhiniyam also, the Bharatiya Sakshi Adhiniyam as well runs on the same presumption that if any statement is given by the accused in the custody or in the presence of the police, such statement shall bear no evidentiary value, because the law runs on a presumption that the accused may be intimidated or that the police may use some a violent form of measures. The police may resort to some violent measures in order to extract information out of the accused. In order to prevent all that and in order to safeguard the rights of the accused while also safeguarding the integrity of the investigation, the accused is sent to judicial custody. So see, the judicial custody is also not of a perpetual nature. It comes with its own statutory time limitations. If the investigation in offences that are punishable with either death or imprisonment for life or imprisonment for 10 years or upwards is not completed, the judicial custody can be extended up till 90 days. However, this judicial custody is also not of a perpetual nature. It comes with its own statutory time limitations. So, if the offences are of such a nature that are punishable with either death or imprisonment for life or any form of imprisonment exceeding 10 years, in that case, the magistrate cannot prescribe judicial custody for a period extending 90 days. However, if it is an offence punishable with any other form of punishment below 10 years, in that case, the magistrate can order judicial custody only for a maximum period of 60 days. So that is the difference between police custody, pre-trial detention as we call it, or judicial custody.
Okay, ma'am. Though our constitution tells us that we have the legal representation right, ma'am, but do you think that it is ensured in all of the stages, ensuring like arresting and interrogation?
See, if we consider the Indian criminal justice system in detail, we'll see that we follow an adversarial system. And being an adversarial system, we give importance to the rights of the accused as much as we give importance to the rights of the victim. Right? So the accused is given every opportunity of coming clean in front of the court of law. Also, if we speak of principles of natural justice, the principles of natural justice also put forward very clearly that an accused should be given an equal opportunity of putting forward his case. Right? Fair trial is recognized as a fundamental right under the Indian Constitution. And in order to ensure this fair trial is being meted out, this right of representation is one important element. Article 39A of the Constitution of India very clearly casts this obligation upon the state itself, that in order to ensure justice and in order to ensure an opportunity of securing justice for themselves, every individual, in case if they are not able to have recourse to legal advice or legal counseling, they should be given free legal aid. So the states have been given an obligation of coming up with certain schemes or statutes or any other form of steps that they believe are important in order to enforce and in order to secure this opportunity of free legal aid. We have our Legal Services Authorities Act, right? Legal Services Authorities Act very clearly recognizes and acknowledges and enumerates a list of people who have the right to demand a free legal aid in case if they do not have a legal counsel of their own, right? And in cases where this kind of legal aid is denied, we also have an appellate mechanism. Similarly, if we look at Article 22, in clause 1 of Article 22, very clearly the Constitution has elaborated that every individual shall have a right to be represented by a counsel of his own choice. So this right of representation, and speaking specifically of legal aid, this is available to the accused at almost all stages of the trial. We have our right of representation at the stage of arrest. We have a right of representation at the stage of interrogation as well. If we refer the Bharatiya Nagarik Suraksha Sanhita, and if we look at section 38 of the Bharatiya Nagarik Suraksha Sanhita, we will see that the statute very clearly mentions that every accused shall have a right to be accompanied with a counsel during interrogation. However, the counsel may not be present throughout the entirety of interrogation, right? So again, this legal aid as an option to the accused is available at almost all the stages. However, if we talk about interrogation in specific detail, if we talk about interrogation specifically, we'll see that the courts have adopted a different juristic opinion in this regard. So we have cases wherein the courts have gone to the extent of allowing the accused to be accompanied by a counsel throughout the interrogation. You pick up the case of Amir Ajmal Kasab, you pick up P.L. Dani, you pick up Shelby versus State of Karnataka. In almost all those cases, an accused's right to be accompanied with a counsel throughout the entirety of the interrogation has very much been recognized by the judiciary. So even though the statute in section 38 very clearly mentions that the counsel may not be required to be present throughout the interrogation, however, in the interest of justice, however, in the interest of safeguarding the rights of the accused, the courts have gone to the extent of interpreting it in a manner that allows the accused to be accompanied by a counsel throughout the interrogation.
Ma'am, just now you have mentioned about Article 39A. So what are the bodies which provide legal aid?
So see, as far as the bodies providing legal aid across the country are concerned, we have first of all the Parliament legislated and came up with the Legal Services Authorities Act in 1987. This statute very clearly categorizes and creates a hierarchy of legal service providing authorities. We have the committees for providing legal aid at the district level, then we have the authorities at the state level. We also have something known as the National Authority for Legal Services, which is the NALSA. Then you have your Supreme Court's Legal Aid Committee. So we have different bodies with different jurisdiction that cover the entire mechanism of providing legal aid to the needy. Also, if you look at Section 12 of the Legal Services Authority Act, you will find that the Parliament has given a list of individuals to whom the benefit of this legal aid can be given. So for instance, if the victim is a person belonging to the SC/ST community, or if the victim is an indigent person, or if the victim is a widow, or if the victim is someone who has survived a natural disaster and does not have adequate means, all these people have a right to claim legal aid from the state. The goal is that anyone who does not have access to enough resources should not be left out from pursuit of justice only because of his shortcomings. So see, when we talk about criminal offenders, we are not just talking about white collar crimes. We are not just talking about people who belong to the upper strata of the society. A good chunk of these apprehended people or a good chunk of these accused are people who belong to a very to a lower strata of the society in terms of income and financial status. So in order to cater to those people as well, and in order to ensure that the right to legal aid as promised in Article 39A, or the right to free and fair trial as promised under Article 21 of the Indian Constitution, in order to ensure that all these constitutional safeguards are delivered to each and every member, even the last possible citizen, these statutory provisions play a very important role. So, to summarize all this up, we have the District Legal Services Committee, then we have the State Authority, then we have the National Authority, and we also have a Supreme Court Legal Services Committee.
So, ma'am, as you mentioned 39A, what I feel like in the society is there are a lack of awareness about things. We have seen how in such petty offences people are arrested and detained for a longer duration. What is your opinion in this thing?
See, Vasudha, very, very appropriate question. I must say you have directed this question in the right direction. Lack of awareness is indeed a major challenge when it comes to trial of criminal offences in the country. So much so that the accused in our country serve a long period of time behind the bars awaiting a trial as well. And when it comes to petty offences specifically, a lot of time the accused are not aware of the alternatives available to them. They're not aware that they can, skip the imprisonment part altogether by merely submission of fine, right? So in that case, availability of legal aid becomes very, very important. Also, for under trial prisoners, specifically speaking about under trial prisoners, they become entitled to default bail the moment they serve up to 1/2 of the maximum term of imprisonment prescribed for the offense that they have committed. A lot of times, the accused are not aware of this remedy available. Default bail is available as a matter of right. So, lack of awareness, either it be in grave offences or it be in petty offences, is definitely a major challenge. And I think legal aid can come to the rescue of a lot of people in such a scenario, because every now and then we read a major breaking news in the newspapers where a person has been wrongly convicted for, let's say, 25 years, and ultimately at the end of 25 years it was eventually revealed that the person never committed an offense in the first place. But there cannot be any compensation that can make up for the loss of life of those 25 years. So even in petty offences or any other offences where alternative remedies are available at the disposal of the accused, I think legal aid can play a very major role in highlighting those alternative remedies, thereby saving the accused a lot of hardship and misery behind the bars.
Ma'am, can you please highlight what are the rights of an accused when they are in the police custody or arrested by police?
See, the entire investigation, the entire procedure of investigation, or if I may say so, the entire justice system has been designed in such a manner that right from the moment a complaint is received or an FIR is lodged, or a suo motu cognizance of an offence is taken, right from the very primitive stage until the hearing of the final arguments or until the pronouncement of the judgment, every possible effort is supposed to be taken to ensure the transparency in the trial, right? So even when it comes to an accused, even though there are strong suspicion, there are strong evidences that suggest that a particular offense has been committed by this individual, even though there might be strong sources that report the commission of an offense by a certain individual, even though it might even be an open and shut case, wherein it might be very clear for the investigating agencies to ascertain that this specific accused or this specific individual is the one who has committed this offense. Despite all of this, the accused will mostly or almost never be denied of his right to be heard, right? So when it comes to arrest specifically, or when it comes to detention, pre-trial detention or detention during the trial, every effort is made to ensure that such a detention is not used as a tool of harassment for the accused. So, for example, if an accused of an offense is being arrested, it is the responsibility of the arresting officer to bear a clear and visible mark of identification so that it is easy for the accused to be satisfied about the identity of the person who is apprehending him. Also, if the law or if the nature of the offense so dictates, a warrant should be produced, right? And also the accused at the time of arrest should be informed about his rights, should be informed about the charges that have been leveled against him, the charges that have been mentioned in the FIR or in the complaint. And in case if the accused is a woman, even further and stronger restrictions are placed and stronger safeguards have been put into picture. So for example, no police officer can arrest a woman after sunset and before sunrise. Even in case if they were to do so, they had to obtain the written permission of the magistrate, and they should necessarily be accompanied with a female police officer. And in case if the accused is not at all resisting, right, this lack of resistance on part of the accused will be presumed as his submission to the authority of the police. In case if the accused is a woman also, there will always be a presumption that she is willing to submit her body to the authority of police, and no police officer shall have the right to have access to her body. They cannot physically handle her. Similarly, handcuffing. So even when it comes to handcuffing, an accused now cannot be handcuffed until and unless there is strong physical resistance on part of the accused where he's trying to evade arrest and all. He cannot generally be handcuffed. The Honorable Supreme Court rose to the occasion, addressed this issue in the very famous case of Prem Shankar Shukla versus Delhi administration. And the handcuffing is now definitely, it is almost prohibited. The entire goal behind this is to ensure that we put the accused to trial while also taking cognizance of the fact that he is at the end of the day very much a human, right? We need to look at the humane aspect of an accused also. And a very beautiful amalgamation of human rights into the procedural code in India. You can, if you look at your Bharatiya Nagarik Suraksha Sanhita, if you start right from section 36, you move to section 37 and 38, wherein they are talking about the rights available to accused at the time of arrest. You will see how beautifully all the human rights have been incorporated, right? The accused is being given an enough opportunity of the relatives or the friends of the accused are given an opportunity of being kept in loop regarding his arrest. The accused is informed of his rights. The accused is informed of his right of bail in case if the offence is bailable in nature. It is the duty of the arresting officer to inform the accused that you have a right to bail. Also, the accused has the right to seek representation from a legal counsel of his choice. The accused has a right to be accompanied by a legal counsel. The police cannot even go to the extent of questioning the accused if a legal counsel is not present at that time. Any such statement that may be taken by the accused in the absence of a legal counsel shall bear almost no relevance in the court of law. It shall have no substantive evidentiary value in the court of law, because the court will always run on a presumption that it must have been coercively extracted out of the accused. So all these protections cumulatively infuse a very, very beautiful human right aspect into the criminal trial procedure.
As you have mentioned correctly, I agree with all of the points that you have said. But in a hypothetical question, if a person is denied with the rights that are mentioned in our constitution, that to say legal aid, so how that person can pursue further?
See, one major challenge, like I have mentioned in the beginning of the podcast itself, one major challenge that the entire criminal justice system, or for that matter, the entire idea of legal aid faces is lack of awareness. A lot of incarcerated people, they are absolutely unaware of the rights that are available to them. And it's not only just the people, I think the state and the authorities are equally to be blamed for, because ultimately the onus lies on the state to raise enough awareness about all these rights and all these committees and all these policies that have been put in place. But just in case, despite all sincere efforts, if an accused is unable to secure any form of legal aid for himself, and he himself does not have enough resources to secure justice, that would directly hit at the validity of the outcome of such a trial. Any trial, if it does not give the accused an opportunity of being presented equally and fairly in a court of law, can definitely very easily cross the boundary and fall into the area of mistrial. Any conviction or acquittal arising out of such a trial is definitely can be put to question, and it can even be quashed by the higher authorities. Also, despite applications to the, let's say, to the district committee or to the national committee or to the state committee, if a person is unable to secure legal aid for himself, there are enough appellate authorities that have been established. The accused can move an application before those appellate authorities, and the appellate authorities, if they feel that the accused has is satisfying the criteria laid down under section 12, the appellate authority can direct the necessary committee and the authority to appoint a counsel to the accused in such a case.
Thank you so much, ma'am, for taking out time for us. It was a very knowledgeable session. I hope as much we have learned today, all of our audience would get to learn more. And thank you everyone for watching today's episode.